Hello and welcome to The Leading Question. I'm your host, Steve Wigreiser. Joining us today is Professor Cathy Rosen from Philadelphia's Temple University, the Department of Criminal Justice. Very excited to have Professor Rosen here. Welcome to the show.
Thank you.
And today's question concerns the criminal law, and we've spoken on many occasions about the difference between the civil justice system and the criminal justice system. As most of you know, I'm involved in the civil justice system where victims of negligence, victims of malpractice can seek and receive a compensation for their injuries and their damage. But the defendants, the people we bring claims against in our cases, are not punished. They're not sent to jail. Typically, there's no probation, there's no loss of license, etc. And that is in distinction with the criminal justice system, where there is a punitive remedy that hangs over the heads of those who are accused. And so today's leading question is this: is it possible, Professor Rosen, to reconcile the desire on the part of many citizens for stepped up or tougher law enforcement with the very, very important rights of the accused, the constitutional rights of the accused? Is it an either-or proposition, or is it possible to reconcile the two? To my way of thinking, and I don't practice in your area of expertise, if you emphasize one, and we hear candidates talking all the time, oh, I'm a law and order candidate, etc., are we necessarily sacrificing constitutional protections of the accused? And even though most candidates, and for reasons that I think are obvious, don't typically emphasize the rights of the accused, we do hear about that from time to time on particular issues such as stop and frisk, which we'll talk about. But can both these goals be realized in our system as it's currently structured?
I think the answer is not a clear yes or no. And the reason for that is the sheer volume of our system. The reality of our system is that the model that most of us are familiar with, which is what we see on TV shows or read about in books, true crime books and that sort of thing, is really a very formalized system of a full-blown felony trial for a serious crime. And in that version, that entity, that part of the criminal justice system, people do, for the most part, get guaranteed their full rights, right? And those are the crimes that I think the public is largely concerned about, too. The murders, the armed robberies, the sexual assaults, the crimes that really threaten our safety. Then there's the low-level crimes, the crimes that don't threaten our safety so much, but make us feel really insecure, like retail theft, simple assaults, drug crimes of various sorts. For those crimes, they're really being treated in a very different way in the system. For the most, they're treated in the misdemeanor courts. For the most part, people are just kind of processed through what some people have analogized to an assembly line kind of situation, where you're charged, you're brought to court, you may or may not be released on bail, you get an attorney, the attorney's appointed, you see the attorney maybe at your first appearance, you're encouraged to plead guilty for a whole host of reasons, and in that sense, you're really never getting the opportunity. You get your right to attorney, you waive your rights when you plead guilty, but you're never really getting the opportunity to test the evidence, to make sure that everything is on the up and up. And so we're not getting a lot of due process, if you will, at that stage.
It sounds like in the smaller cases, we are providing constitutional protections light. Is that a reasonable description of what's going on here?
Yeah, I think that's a great way of characterizing it.
The heavier crimes that you've alluded to, the homicides and the rapes, etc., the ones where there is more at stake for the accused, and I don't want to judge the difference in sentencing, because all sentencing is a very negative thing for the accused. But it seems to me that where there is more at stake, perhaps there is more in the way of protections afforded. Is that inaccurate?
I think that's accurate to a degree. Okay. Because the reality is that only about 5% of all cases actually go to trial. So 95% of cases are resolved by guilty pleas.
So it's not like Law and Order, where they all go to trial and you get a result and it all happens within 30 minutes or 60 minutes.
Oh, no, absolutely not. Absolutely not. And in fact, as we all know, sometimes it can take much longer. But the reality, again, the reality is that most cases are resulting guilty pleas. And the fact is that the system would blow up. It would, self-immolate if we had much larger an extent of actual trials. But in those more serious cases where more is at stake, there are more processes that one goes through even before reaching this point where they plead guilty, oftentimes. So the evidence is often more likely to be tested. There'll be time for what we call pretrial motions, which are opportunities to challenge the voluntary nature of a confession, for example,
right.
To challenge the police action in searches and seizures, and if there allegedly are constitutional violations, that sort of thing. But in the long run, you plead guilty, even if there's not a plea bargain per se. It's widely recognized and known that pleading guilty is going to give you a lighter penalty than if you went to trial and were convicted. So we kind of refer to that oftentimes as the trial penalty.
The inducement to plead guilty.
The inducement to plead guilty, is that you won't be faced with the so-called trial penalty, which is that if you put the system through the cost and expense of putting you to trial and you're found guilty anyhow, you're gonna pay for that in some sense of the way and nature of your sentence.
Very interesting. If everybody exercised their right to question everything at every step in the process, we would have to double the number of judges and courtrooms and perhaps prisons.
Doubling is, I think, an understatement, right? But it would be even greater than that, because people have described the system as a pyramid. Right? At the bottom, at the base of the pyramid are the misdemeanor cases, right? Which aren't very serious. They often involve people of color, people who are at the lower end of the socioeconomic scale. And then as you move up to the pinnacle, you get those cases like against President Trump, right, that are kind of these renowned epitome cases or famous murders, O.J. Simpson, Bill Cosby, right? They're not necessarily all involving celebrities, but they're very serious cases and often involving people who have financial resources, because the reality is that to fully avail yourself of the constitutional protections that the system provides, you need money. You need resources. It's not just the quality of lawyers that might vary, based on what you can pay for, but the ability to investigate, the ability to, in the biggest cases, and I'm sure you know about this from the civil system, use trial consultants, as in the O.J. Simpson case, where they were used to great renown. All of that depends upon one's resources.
Bringing in experts, scientific analysis, guidance with jury selection. I mean, that is very expensive. We have to pay it in our cases,
right.
But it's not unusual in our cases to spend six figures just to get the case to the courtroom, and then of course that doubles once we get to the courtroom. And I'm imagining that the average individual can't do that. The average criminal lawyer can't work on a contingent fee basis like we do, because there's no compensation coming. And all of these things promote what I'll call nicely efficiencies in the process. And so really the question is this, and if I can label what you've described as rough justice, and I don't mean to be pejorative, right? Can rough justice still be good justice or good enough justice?
Well,
in your view?
Yeah, that's the $1,000,000 question, I think.
That's why I asked it.
And so, and it's a question that's hard to get a handle on, right? We know that innocent people end up being convicted of crimes they didn't commit at times. We started to learn or be certain of in serious cases like homicide and sexual assault, once we had DNA technology that could go back, look at old cases. Sexual assault is the prime example, where there had been samples of bodily fluids that had been connected to defendants based on blood type. And we all know that, I think there are 3 kinds of blood type. Might be a little wrong there, but huge percentages of the population have each of those blood types. So just to say it's the same blood type, well, you could exclude it by the wrong blood type, but saying it's the same blood type doesn't do anything. Once we were able to go back and use DNA testing, we were able to find that there were people who had been convicted of serious rapes who were excluded by DNA testing, who could not have been the offender, right? And so that started people questioning, are there maybe other places in which the system there are errors in the system? Just as an aside, the DNA problem has become better lately. There have been in the last few years, there are fewer DNA exonerations as DNA testing has become a regular process in the investigation of sexual assaults and other crimes where there's bodily fluids that may be able to be used for that.
So there are fewer convictions, therefore fewer exonerations, because there are fewer wrongfully accused.
Exactly.
Wrongfully convicted.
Exactly.
Okay.
So that's one of the places where, actually forensics have helped prevent erroneous convictions. We have these mistakes where we can prove actual innocence. We know that there's other instances of false confessions, mistaken witness identification, issues with forensics, other kinds of forensics than DNA that have also led to people who have later, new evidence has shown to be innocent of crimes. But what we know about are largely the serious crimes. At the misdemeanor level, the question becomes much more complicated because we don't have the incentives to go back and challenge the convictions. Challenging a conviction can take years. It needs to get people on your side. A lot of the Innocence Project people, the innocence attorneys, will only take cases in which they're really going to save someone from having been incarcerated for a long time, that sort of, or perhaps from a death penalty even.
All felony cases.
Yeah, felony cases with serious penalties. And the misdemeanor level, we just don't know. But what we have to assume is because of the nature of the justice there, that there are, and the fact that there are tremendous incentives for people, even if they say, if they're innocent, if they say, I didn't do it, right? There are tremendous incentives to just plead guilty and get it over with. So we can assume, and people who, legal scholars who have worked in the misdemeanor courts will verify that indeed there are many, many cases in which if people had challenged and availed themselves of the full panoply of opportunities to challenge the evidence, go to trial, that sort of thing, that they may well have been freed, or they may well have been innocent. For example, a Professor Alexander Nadapoff, who worked as a federal prosecutor in the Baltimore misdemeanor courts, talks about how at one point, a decade or so ago, the Baltimore police would go out and just round up people who they suspected of drug dealing and carrying guns and those sorts of things. You know, groups of people on corners, that sort of thing, and charge them with loitering.
Right.
Well, none of these people, or many of these people, I won't say none of them, had actually met the statutory definition of loitering under Maryland law. But yet, they'd be hauled in, they'd be incarcerated, they might have had a high bail set. And so for them, the value proposition is just plead guilty. I'll be on probation, but I'll go home right away, right?
But there may be implications to doing that when later down the road a misdemeanor is still on your record unless it's expunged. I'm thinking of an experience where a close family member was caught up in one of those speed traps and showed up for, I guess it was the district magistrate's court. If you're willing to plead guilty to traveling 5 miles an hour over the speed limit, we can process you now and you'll be out in 15 minutes. It was expedient. It didn't cost them anything, didn't cost them time from work. And I'm sensing some sort of analogy here. What do you think?
Oh, there's an absolute analogy. Except that what we also have are people who are living much more precariously than probably the people who were in this
Villanova.
Exactly.
Yeah.
So, you know, in the Philadelphia Municipal Court, you have people who are living very precariously, who can't miss a day of work, who children might be left alone, you know, whatever the case may be.
Right.
And so for them, the incentives are much higher, but probably the potential costs are much higher as well.
Right.
Because now they have a conviction on their record. And so next time they have an encounter with the criminal justice system, which is likely to happen because of the nature of their circumstances, right? They will have this conviction on their record, and you can't go back and say, "Oh, wait, you know, I just did that because I needed to get, I didn't want to lose my job,"
right,
or whatever it may be.
And the judge goes through, I'll say, a pro forma voir dire. Do you understand what you've been accused of? Do you understand that you have the right to plead not guilty and proceed to trial? Do you understand that you have a right to a lawyer? And in order to get the guilty plea to the misdemeanor, you have to say yes to everything. No doubt and I don't mean to cast aspersions at public defenders, but no doubt that's the advice that's being given to their clients. And so they can't go back. That's all in the record. There's a record of them having fully understood their rights and making an informed decision.
Absolutely. And yeah, once a client decides to plead guilty, any lawyer is going to say, okay, just answer yes to every question. And if they have time, which they may or may not, at the lowest levels of the misdemeanor courts, they'll go over the colloquy with them, kind of practice. In the lowest levels, they're meeting this person, you know, for an early guilty plea just because they want to get out when they can't raise bail or whatever. They're meeting this person in the courtroom, you know, at a preliminary hearing, and the person is saying, okay, I'll plead guilty, right? And so they're going through it very, very quickly. One of the one of the criticisms is because, again, they're guilty pleas for serious felonies all the time too.
Sure.
And one of the, and some of those guilty pleas, even though a guilty plea basically is a confession of guilt, it's turned out that people who plead guilty are sometimes also innocent of the crimes that they've pled guilty to, even the serious crimes. And so one of the suggestions for reform is that judges, when they accept guilty pleas, demand more of a factual record to support the plea and be more critical of that. So the way a guilty plea, you don't just plead guilty, the prosecutor has to recite some evidence that shows that the person committed the crime. And it can be very pro forma. There's no challenge to that evidence, right? There's no right to cross-examination. The defense doesn't give their version of the story. But one of the suggestions is that demanding more evidence and the judge taking a more critical look at the evidence, because that's all the judge knows. The judge doesn't have this whole record of the investigation of the case.
Sure. So the facts come out.
What the judge does have the authority to do is to reject the guilty plea.
The problem with the proposals and suggestions that you've mentioned, and I'm not labeling them ivory tower suggestions, but some might, is that you're now messing with a judge's docket. Judge has 75 cases that have to be cleared on Monday because there's 75 more coming in on Tuesday. And if you want me to spend an additional 15 minutes with each individual who has an attorney, then the system begins to break down a little bit. And I think that that's something, and I know there are judges in academia, and I know that there's interaction. But I think these are the kinds of things, whether they're said or not said, that are realistic motivators to the efficient administration of justice, if I can say that.
Absolutely. And that time and money are driving everyone.
That's right.
They're driving the judge, they're driving the prosecutor, and they're driving the defense attorney, whether it's a public defender or a private defense attorney. Again, unless you're at those highest echelons, because the private defense attorney isn't getting paid very much either. And he or she have a lot of cases in order to make enough money to survive.
That's right. And
they have to, that's a whole other thing. But so, maybe one of the answers, if we get back to your original question, which is, well, the public wants law and order, right? They want to see people, pay for their crimes, or at least the punishments be high enough that they theoretically deter the crimes, which doesn't work, a whole other topic. Yeah. But anyhow, maybe one of the answers is, well, we need to dedicate more money to the criminal justice system, have more judges, pay public defenders better, be able to provide forensics help to both sides, or have more qualified forensic scientists who work for the government usually, etc. So maybe that's part of the answer.
But you have to buy into the proposition, and I'm going to butcher this because I don't remember where it comes from, but it is better for 10 guilty people to walk free than one innocent person be in prison. The face of the criminal justice system for most people is the police officer, the cop on the beat. In some cases, the neighborhood police officer, but frequently not. You've been looking at these issues. You've written for police officers. You've studied policing. In your view, is it more difficult to be a police officer today than it was when you first started teaching and studying criminal justice?
Probably, and that's just because, I would say that only because I think there's more public discourse, more political discourse focused on policing. I think and I think the other problem is there's more guns. And the fact that there are so many more guns out there, at least from a police officer perspective, makes their job that much more dangerous. So I think we have those kind of two very distinct things that make the job harder. One is that people are more likely to be anti-police, see the police as oppressors, etc., and also that the police perceive of their job as being more dangerous, although I think they always thought of it as being dangerous. So it's just that greater number of guns out there.
It seems to me that when I turn on the news, police departments are always telling us that it's very difficult to hire enough police officers, and we want to increase police officers in some cities. So I presumed it may have something to do with the lack of respect police officers now feel. Similar question. Do you believe that community norms and expectations should guide law enforcement?
I think that for law enforcement to be effective, there has to be a buy-in to what we call community-based policing or community-oriented policing, right? Where the officers need to understand the community that they're working in, and they need to be seen as cooperating with the law and order needs or the security needs of that community.
I'm not talking about crimes with victims. I'm talking about the panoply of victimless crimes like noise ordinances, open containers, marijuana use, if it's still illegal in Pennsylvania, I can't remember, et cetera, et cetera. Well,
I think it is.
Okay, because it seems to me that what is too much noise at Broad and Shunk may be different than it is at Broad and Pine or Broad and Diamond or Broad and Cheltenham. And so if the police are attuned to the community thinking about that, then perhaps law enforcement has more credibility when it comes to other matters. What is your thinking about that?
Well, I think that helps, but I think that what you've pointed out is kind of the tremendous discretion that some of these low-level crimes like noise ordinances or vagrancy or loitering, an example we used before, or even possession of marijuana, create for law enforcement, right? They can't, just as if we use the example that everybody's more familiar with of driving, virtually everyone drives, they can't possibly enforce the law against all the people who speed, right? We all have our rule of thumb. You can go 10 miles over the speed limit, right? Whatever your rule of thumb may be. But they can't possibly enforce because nobody's following that law. So they have to make decisions, right? And it's the way they make those decisions that starts to become questionable, right? And that starts to lead to accusations of racial profiling, of unfair enforcement, etc. The fact that police, it seems to people, and statistical evidence backs this up, shows this, that police are more than likely to stop people of color, men of color, particularly young men of color, that they're more likely to, once they've stopped them, whether it's in a car or as pedestrians in what we call a stop and frisk, that they're more likely to engage in a search, which may or may not be legal, and that they're more likely to, then arrest them if they find anything or any reason to arrest them and bring them in, and then the person is now involved in the misdemeanor system.
Understood.
There was a study that was published in the 1980s or 90s by a couple of criminologists called the broken windows, to develop the broken windows theory. And the idea of broken windows was that disorder in a community, broken windows, if you will, litter, that sort of thing, badly kept homes, would lead to greater disorder. And so a policing philosophy was developed based upon this broken windows theory. And it was the idea that what we need to do is stop this crime at this low level in order to deter or prevent bigger crimes, right? And it was first adopted in New York, and then LA, and then in Philadelphia. Mayor Nutter wanted to, start stop and frisk as a policy. Stop and frisk was one of the main things that was done for that. And that approach to policing has gained a whole lot of criticism, and there have been a host of studies done by quantitative criminologists and qualitative criminologists that show that stop and frisk and other methods of broken windows policing do in fact result in racial profiling, that the people who are targeted are more likely to be people of color, much more likely than white people.
But does stop and frisk, or the so-called Terry stops, deter crime?
Well, that's what we're not sure of, okay? So,
because you mentioned the mayor, I believe our current mayor, Sherelle Parker, believes in, now she makes the distinction, she calls them Terry stops, meaning these are stop and frisks with reasonable justification. It's confusing to me. It sounds more palatable when you say it that way, but in reality, what is reasonable justification? It's the same thing.
And it's not fair. So Terry versus Ohio was a case that was decided in the 1970s that said that stop and frisk, which was something that police had been doing on a different level than the kind of stop and frisk they do today, was constitutional. There were, I won't get into the legal nuances of this.
Because we're a half-hour show.
Right. But basically it approved this. It said it passed muster under the Fourth Amendment. But what it said is that you had to have, in order to do a stop, you had to have what they refer to as individualized reasonable suspicion. It's less than probable cause, which is what you need for an arrest or a search. Probable cause isn't a whole lot. Reasonable suspicion is even less. But it was supposed to be individualized. It was supposed to be focused on this person as opposed to just kind of this broader, like, well, kind of everybody in this neighborhood is under suspicion, or everybody in this bar where we think they're selling weed is under suspicion, right? It had to be focused on the individual. That was then, the way stop and frisk has been used now as an arm of broken windows policing is broader. It's still always supposedly constitutional. There's still always reasonable suspicion. But now, as opposed to the situation in Terry, where we have police officers who see someone who they believe is about to rob a jewelry store in downtown Cleveland, right, in kind of a seedy part of downtown Cleveland. Now, we're saying we're going to use stop and frisk as a method to, in Philadelphia, get weapons off the street, right? So anyone who we see who we have reasonable suspicion to believe might have a weapon, we're going to stop, right? And so we make pedestrian stops all over the place. And we say things like, oh, baggy pants, bulge in the waistband, jackets like leaning down on one side, like there's a gun in their pocket, that sort of thing. The reality is that the percentage of cases of stop and frisk in which they've actually found weapons is minuscule. Minuscule. There's another small percentage in which, as opposed to finding weapons, they end up finding drugs because they ask people to empty their pockets and that sort of thing, which you don't have to do if they just ask you. But anyhow, but are you going to say no to the policeman, right? So, right, exactly. So Have they found weapons? Have they gotten weapons off the streets through this method? Well, if that's our question, no. But people, one of my former colleagues, would argue that the reason they're not finding weapons is because the knowledge that one could be stopped and frisked at any moment means that you're not carrying that weapon with you. And
it's a bit of a leap, but it doesn't mean that your colleague is wrong.
Right. We don't have proof of that. It's just, but I think that's what Sherelle Parker and the people in the police department that's definitely the Philadelphia Police Department argument, that this is an effective method of keeping the guns home. We also know that most killings are pretty impulsive, and so if the gun isn't on you, it's at least a little bit of time to cool off before you go get it from wherever it's hidden and use it.
Makes sense. I could talk about these issues indefinitely, and there's so many issues that I wanted to talk to you about, but I think we need to talk about what is barraging our television screens these days. And when I turn on the TV, I frequently see images of immigration and custom enforcement officers with their face masks and goggles, charging into Home Depots and picking people up in parking lots. And every once in a while, there are some discussion about the way that they interact with local law enforcement. And for our viewers, we have a multifaceted law enforcement system in our country. We have federal officers, we have state officers, everybody's heard of the state police, and we have local officers. And sometimes in these television scenes, you see a mixture of all of them. Plus, of late, the United States Marines. I mean, it's a very confusing law enforcement situation. So if you could take a few moments and just sort of describe the hierarchy and how you believe it should work, and then I'd like to know your opinion as to whether or not local law enforcement is obliged to assist officers, for example, from immigration and customs enforcement. I know they're not allowed to impede them. I don't know why I know that, but it's intuitive to me. But are they required to assist? So I've given you quite a few questions there.
And
I think that this is very, very current.
So we do have a number of layers of law enforcement, and just like we have a number of layers of criminal justice system, really, there's the federal layer, the state level and layer, and the local layer. Local is considered state in various ways, or it's under state authority for the most part. The Constitution actually divides, we think about the rights it gives us, we think about the courts, and we think about, these days, executive power and executive privilege, and the division of power between the different arms of government. But one of the things that the Constitution also does is divide powers between states and national government. What we sometimes refer to as states' rights, when we're saying, well, the state has the power to do this, the state should be able to make decisions about certain things. One of the things that the Constitution gives the federal government is power over immigration, customs, and naturalization, right? And so ICE and other federal law enforcement is really working under federal power, has rights to enforce federal law, not state law. The FBI often works in conjunction with local police on various kinds of investigations, giving local police, especially in smaller places where they don't have the expertise that big cities like Philadelphia have, assistance in major crimes, that sort of thing. But basically, they're enforcing federal law, which includes immigration law. Okay. State police and local police are enforcing state law. which doesn't include immigration. So Texas recently passed a law that gave its state the state law enforcement power to enforce federal law. Whether that's constitutional or not is still up in the air. So it's again, it's the federal government that's enforcing the immigration law. As far as and it's confusing because the ICE people are wearing vests and jackets that say police.
Right.
They don't say ICE, right? So, or they might say ICE in smaller letters and we just don't see them, but they big things that say police. So it gets a little confusing with those images on television, exactly who they are. As far as local law enforcement's interaction, for a long time, local law enforcement was not supposed to enforce immigration law at all. A number of years ago, there were laws passed that gave local law enforcement the power to do that under certification from ICE. And so they can assist if they want to, but they don't have to. And so in LA, in Philadelphia, in other so-called sanctuary jurisdictions, sanctuary cities, the police will say, we're not going to do that. You're not going to, if you will, deputize us to go in and help you raid Home Depots, help you pull people out of parking lots, help you go into houses where you might have a warrant to seize someone, because you need a warrant to arrest somebody in a house. On the streets, you don't need a warrant, which is why a lot of this is happening out in the open. So they won't do that. In Philadelphia, I guess we're not calling it a sanctuary city anymore. We're calling it a welcoming city. But it might just be a matter of words as far as anyone can tell. What's happening here is that when people are arrested, if ICE has access to data as to who's been arrested, but it takes them some time to go through that and figure out if this person may be undocumented or not. So what ICE will often do is they'll try to issue what's called a detainer, which requires the police to hold someone for 48 hours after they otherwise would have released them, whether it's on bail or they just don't have enough evidence or whatever it may be. Or even at the end of serving a sentence, a minor kind of sentence.
These are people being held by local law enforcement.
People being held by local law enforcement.
So the federal agency, ICE, is issuing...
what's called a detainer.
On their own or through some court?
No, on their own. Okay. And this is not a warrant. This is just it's a piece of paper, if you will, although it's probably not literally paper anymore, that says, please hold this person another 48 hours while we do further investigation as to their immigration status. The Philadelphia police won't do that. And it may actually be illegal for them to do it. There's a Third Circuit precedent. Third Circuit's the federal court that governs Philadelphia and southeastern Pennsylvania. There's a Third Circuit precedent that held that the Allentown police had violated the Constitution by holding someone on a detainer. So I don't know that would hold up if it was ever appealed to the Supreme Court. It would take a whole new case at this point because it was a number of years ago. But it may not even be legal to do that. On the other hand, so the Philadelphia police aren't doing that. Usually the people involved in these are, again, people who A, may have only been arrested and not convicted of anything yet, so we don't even know if they've committed a crime. Being undocumented, again, this is very confusing to most people, is not a crime. It's a civil violation, simply being undocumented. And so that in and of itself is not a crime. People who have been convicted of serious felonies and are about to be released from prison, ICE will know about that, and the Philadelphia authorities will wait for them to get a warrant, which is a judicial document that says, please hold this person. And so in those cases, they do wait for them to get a warrant. So a lot of the dialogue around this, right, that, oh, these sanctuary cities are releasing dangerous criminals, whatever a dangerous criminal may be, really aren't true. What they're doing is they're releasing people who may not be criminals at all, and even if they aren't particularly dangerous criminals. And they're doing that in part to be nice, to treat the residents nicely, but there's also some more instrumental reasons, which include the fact that the police, in order to be effective, the police need the immigrant population to cooperate with them, right? And if the immigrant population is frightened, is angry, that they're not going to do that. And so law enforcement is going to become more difficult in those in heavily immigrant neighborhoods.
So the ICE activities may be interfering with local law enforcement, and then the question, for certainly not for me or even you, is whether it's worth it. And from a local perspective, it would seem not. If you can destroy community relationships with the Philadelphia Police Department by deporting 5 people,
right,
it wouldn't seem to make sense. But again, that's for other people to decide. In looking at the images, and I have no other information than what I see on the television, it seems to me that sometimes their raids are targeted to a particular individual or a group of individuals. And then sometimes I get the feeling that they are looking for people who look like they might be undocumented immigrants. Is that legal?
It's not. I was just going to say, I gotten that impression too, and there have been some anecdotal stories about people who are citizens, who are veterans, military veterans, whatever, who say, yeah, I was picked up, right? So there's a lot of stories. It's not. I mean, that's really an example of a different kind of racial profiling that simply says, because you look this way, we're going to pick you up. And there's Supreme Court precedent on that kind of profiling. In Arizona, about in the early 2000s, a law was passed that was called colloquially the show your papers law. But basically what that did was it allowed police, most famously Sheriff Arpaio in Phoenix, to stop anyone they wanted. And so what the Phoenix, Maricopa County is the name of the county, yeah. What Arpaio would do is he started sending out, not all the time, but there would be days when he would send out patrols, like roving patrols that would stop cars, basically with people who looked Mexican. So a lawsuit was filed by the ACLU and a bunch of individuals who had been caught up in this. And in this lawsuit, actually one of my former colleagues, a professor named Ralph Taylor, who's a statistical genius in my mind, was able to get the records and show statistically that indeed, despite the sheriff department's denials that, we're stopping the cars for traffic violations, whatever it may be, that in fact they were stopping them because the people inside looked to be Mexican. They were able to show that if there were people with Mexican last names in the car, that the detention was longer than if their people weren't, and that sort of thing. And that was held to be a violation of the Fourth Amendment and the Equal Protection Clause. And so you're not supposed to be doing that. Proving it just as with the question of whether stop and frisk involves racial profiling, the question of whether traffic stops on I-95 in New Jersey involve racial profiling, is extremely, extremely difficult. Because, of course, the law enforcement officials will say, oh, no, that's not why we did it. It's always easy to find another excuse for why one stopped a car or stopped a pedestrian.
Right.
But indeed, it's against the law. So, again, with the courts these days, maybe the lower courts would find it unconstitutional if it was challenged, but I don't have a lot of faith that the Supreme Court would uphold that.
Right. I think and I hope that the shock and awe aspect of these ICE arrests is going to become less frequent, and perhaps because it will be perceived as less necessary by the current administration, and that some reasonable rules of the road will come from this, where people understand who are the police and who are not, and don't have to worry about every masked person with a gun as potentially not being a police officer, and on and on and on. We're right at the beginning of this whole thing. Who knows where it's going to end?
Yeah,
right?
I think we really don't, and it's really frightening. I mean, what's also frightening are kind of the students, the international students the woman who at Tufts who was just accosted on the street by these masked men. I mean,
She didn't know.
She had no idea. That's really, really frightening.
But that doesn't mean that most people don't agree that we need to protect our borders and know who is in the country, et cetera, et cetera. I think there's plenty of room in our American house for all points of view, but I think logic needs to prevail, and I think right now we're at the beginning of this process. It needs to settle down. There needs to be rules of the road, and I hope that happens, and I hope it happens soon. I want you to know it was a pleasure to have you.
Thank you. It was a pleasure to be here.
I hope that you will come back. A number of topics I'm interested in talking about. And to our viewers, stay interested, stay involved, and don't be afraid to ask the leading question. See you next show.